We will now hear argument in case number 02-0331, United States v. O'Connor, et al., counsel for the petitioner. Ms. Chief Justice, may it please the Court. The Constitution grants the power to Congress to regulate commerce, which is found in Article 1, Section 8, Clause 3 of the Constitution. The Court's precedents on many cases states that commercial activity is within Congress's scope to regulate. Although different from the Court's precedents regarding the Commerce Clause, we argue this includes the Anti-Betting Statute of 2010. The Court should rule in favor of the petitioners for pragmatic reasons arising from the dangers of gambling, even in friendly betting. In the United States First Derby of 1941, the Court unanimously voted that Congress can regulate commerce in the United States. In the case, Fred W. Darby was charged with violation of section of the Fair Labor Standards Act of 1938. The Fair Labor Act was in place to help control areas of employment such as workers' hours and employees' pay. Darby was a lumber manufacturer and began selling lumber out of his state of employment and was charged with violating the Fair Labor Act. Congress has constitutional power to control shipment and interstate commerce of lumber manufactured both in and out of the state. Arising out of the ruling of this case, Congress may regulate all commerce in the United States as established in the United States v. Darby. As regards to the current case at hand, Congress has resolved that betting is a part of commercial activity that must be regulated and has a negative impact on the United States economy. The shipping of manufactured goods out of the state deals with commerce and the power of Congress over interstate commerce, which was decided in Gibbons v. Ogden to prescribe the rule by which commerce is governed. Gibbons v. Ogden protects commerce in the United States and the power Congress has in regulating commerce in the United States. Interstate commerce reflects on the nation's economy. Thus, Congress is compelled by the Constitution to regulate the commerce clause.
Gibbons v. Ogden is not in the simulation cases?
I'm referring from Gibbons v. Ogden, which was present in Fred W. Darby's case. So, interstate commerce reflects on the nation's economy. Thus, Congress is compelled by the Constitution to regulate all commerce in the United States. Commerce clause should be accessed by what it regulates, not by what it reflects. Any thoughts?
So I have a question. So I'm interested to hear more about how betting is supposed to be considered commerce, because gambling doesn't involve the exchange of goods and services, since it's primarily relies on luck. So I was wondering if you had any kind of further details on why that should be considered commerce, because there's no real exchange of good or service in that case.
There is no exchange in good and service, but there also is betting involved in these situations, even in friendly betting. So that also would go forth to be in the Commerce Clause, where there is an exchange of betting, whether it's like goods or services. That is definitely like part of the Commerce Clause.
How do you distinguish between what friendly betting is and like what can be a threat to commerce? Like, where do you draw the line?
I think that friendly betting is definitely like it's a threat to the nation's economy, because it is, even in friendly betting, there is money being exchanged. So although it's friendly and not on the state, it's also affecting the economy because it is an exchange.
And like in instances of like small friendly betting, like how do you regulate that? Like, wouldn't you assume that there would be a large portion of the population that does friendly betting every day?
There is, I would think, a lot of people that are friendly betting, but I think that it also should be regulated because we can't have everybody betting going against the Commerce Clause. Pragmatically, couldn't one also argue that friendly betting would not, in fact, have a substantial effect on the economy or criminal activity? I think that friendly betting leads to cases that are definitely significant on the nation.
Could you explain to me about how exactly this could be ruled under the ABS? Can you explain how this would be ruled as interstate, even though it's only between 3 people interstate?
I think by looking at different cases that we will bring forth throughout the trial, you can see where not just in momentary items, but also in different cases that we'll explore.
We would now like to provide some applications for the briefs that the respondents have provided. The respondents argue two things, the veracity of the first of which allows them to argue the second. First, they argue that friendly betting does not create an environment, an atmosphere that enables organized crime to gain illegal benefits from betting. Second, they argue that the federal government oversteps its authority when it's legislating on a social evil under the Commerce Clause. To the first point, the respondents' claim amounts to the following. The findings of the legislature that it included as part of the ABS are incorrect. Now, why does it amount to this? This is because Congress found that even instances of friendly betting can create an atmosphere that eventually benefits organized crime. To insist otherwise is to argue against the finding itself. I would like to remind the court of Justice Stevens' dissent in U.S. v. Lopez, where he said, courts must give Congress a degree of leeway in determining the existence of a significant factual connection between the regulated activity and interstate commerce. Both because the Constitution delegates the commerce power directly to Congress, and because the determination requires an empirical judgment of the kind that a legislature is more likely than a court to make that case.
Can you reiterate what the factual connection is between crime and friendly betting? What the empirical proof of that is?
The empirical proof of that was provided in the records as part of the bill that Congress passed when it enacted the ABS in 2010. So all the records are there. Continuing with what I was saying, a legislature is more likely to make such decisions, such findings with greater accuracy in court. The traditional words rational basis capture this leeway. Thus, the specific question before us, as the court recognizes, is not whether the regulated activity is sufficient to affect interstate commerce, but whether Congress could have had a rational basis for so concluding. Therefore, the question here is not whether friendly betting does actually lead to benefits for organized crime. The question here is, did Congress have a rational basis to conclude that instances of friendly betting could potentially benefit organized crime? And according to the findings that were provided in and as part of the bill, the ABS, it was clear that Congress did show and did find, in fact, a rational link between instances of friendly betting and benefits for organized crime. The second point that they make, they argue that legislating on friendly betting is unconstitutional because the federal government, cannot tell people how to spend their money. Now, this argument can be addressed by appealing the championing aims. The gist of the court's ruling, as enshrined in that precedent, was that the federal government can legislate on matters that constitute possible social evils if those social evils sufficiently impact interstate commerce, or impact interstate commerce at all. Justice Harlan said in the majority opinion that surely it will not be said to be a part of anyone's liberty, so recognized by the supreme law of the land, that he should be allowed to introduce into commerce among states an element that will be confessedly injurious to the public morals. Now, as mentioned previously, the legislator's findings do show that there is a rational link between friendly betting and the illegal benefits to organized crime. Obviously, organized crime is an element that impacts interstate commerce. In that capacity, then it seems clear that Congress could legislate on those matters, and ABS is therefore constitutional. Now, carrying on in the case of the petitioners, I would like to show why the case at hand is similar to precedents enshrined in Chatham v. Ames 1, and why it is very importantly dissimilar to the precedents enshrined in U.S. v. Lopez and U.S. v. Moot. Quickly with regards to U.S. v. Lopez, as part of U.S. v. Lopez, one of the criticisms of the legislature by the Supreme Court was that Congress did not include any findings or any records as part of the bill when it passed the Country School Zones Act. Here, a very clear distinction arises. The first distinction is that as part of the ABS, Congress did include findings, they did include all the material they had, that they processed when they were passing this statute. So that is the first difference. Second, Chief Justice Rehnquist said that there is a very indirect connection between having guns in or near schools and how it affects commerce. While that might be the case there, here, the activity that the court is trying to regulate is directly connected to commerce. It in fact concerns the barter and sale of items, which is what takes place when we get something. In fact, the case facts also state that in some cases where the loser of the bet wasn't able to pay up, they provided small certain services, like washing cars, or washing laundry, or taking the dog. So there was...
Just because it's directly connected, how does that prove that it has a widespread effect on commerce, on national commerce?
That in itself, of course, does not prove that it has an effect on interstate commerce, but when that is taken together with the findings that Congress included as part of the bill, that shows that Congress did have a rational basis to conclude that friendly betting, instances of friendly betting, do benefit organized crime.
I'm interested in this word substantial because it says that you need to have substantial impacts on interstate commerce, and when you look at the total amount that was exchanged, it was $200 and then $75 worth of goods and services. And when you look at sporting events, it said it was divided between primarily baseball, basketball, and football, and that's a lot of games throughout a year. And that was over the course of 4 years. So the total, if you take 200 divided by 4, is $50 per year, divided by all those games. So I'm questioning how you can justify that this was a substantial effect if it was that low, like that low amount of money. And to her point, there was no interstate exchanging. It was just a matter of 4 friends. And the only exchange was like laundry or a dog walk or something like that. So I'm just interested to see what you think the word substantial means in this case.
Well, I think one way to answer that question comes up when we will address the precedent China and Vickers v. Philbin. So part of your question will be answered there. Another way to answer the question is to say that, of course, bets totaling or amounting up to $200 in itself would not benefit organized crime. But that is not the issue. The issue here is whether those bets can create an atmosphere that is not just enough that we have a society that tolerates the illegal benefits of organized crime. And I think, Justice Khan, we can all agree that the illegal benefits of organized crime, we should do everything we can to avert that, avert even the possibility of that.
And to that point, if betting is already a very substantial action that happens throughout the country, do you think that's too late? Do you think this is a last-minute effort to counteract that? Because I would argue that the vast majority of people that watch sporting events probably place bets on it.
Right. Well,
I would think that this atmosphere that's trying to be prevented is kind of already there, if you understand my point.
yes, I do, but I'm not certain what that has to do with the constitutionality of the current statute at hand.
I would like to expand on the pragmatic issues that Council Crucial brought up. In 1964, Article 2 of the Civil Rights Act of 1964 was brought to the Supreme Court in Heart of Atlanta Motel v. U.S. Expanding upon the friendly betting issue, in 1964, the Heart of Atlanta Motel was found to be discriminated against Black American customers from out of state. Although these transactions never totaled more than small sum of dollars. In total, the discrimination that Black Americans face created a substantial effect on interstate commerce because even though the individual transactions were small, the amount of transactions that were discriminated against created a large impact on the commerce. This, with the ABS of 2010, relates to the anti-betting statute because even though small transactions between, in this case, totaling only $200 over 4 years, even though these cases only total $200, small amounts of transactions between one person or one group can total up more and more over 4 years. In addition, these issues can also be prevalent over the entire country. In the Harvard v. Motel case, Article 2 doesn't pertain to the friendly betting issue because friendly betting isn't discriminatory as was the issue with the Article 2 of the Civil Rights Act. But the issue covers the case relating to the anti-betting statute because the issue is on the impact of interstate commerce. If this was permissible, cases could add up to millions or billions of dollars per year, just as much as friendly betting can. And if this was permissible, the discriminatory policies, then the same issues can arise with friendly betting.
Do we have any evidence